This video is a summary of Customs Act 1962, and the topic covers almost 5% of the CMA Inter syllabus, and you can expect around 5 marks from this topic. It's a very simple topic and it is high scoring as well. So let us just go into the act and summarize the entire act in maybe 10 to 15 minutes. So Customs Act 1962 was enacted in 1962 and it was effective from 1st February 1963. For any act to obtain the power to levy a duty, it has to be delegated through the Constitution. So entry number 83 of List 1, Schedule 7 of the Constitution empowers Union government to collect import duty and export duty on the goods imported and exported from India. So it is entry number 83 of List 1 of Schedule 7. Applicability of Customs Act. Customs Act is applicable to the whole of India, including the territorial waters. Territorial water is 12 nautical miles from our coastal baseline, and to exclusive economic zone, which is 200 nautical miles from the coastal baseline, certain special provisions of the Act is applicable. That is, those provisions relating to the water column and the continental shelf where India has sovereign rights. So it applies to the whole of India, including territorial waters, which is 12 nautical miles, and certain provisions is applicable to exclusive economic zones as well, which is 200 nautical miles from our coastal baseline. Now, what is the logic behind Customs Act and why do we collect duty? We are manufacturing a product at maybe $10 in India, and post profit margin and taxes being added, it is available in the domestic market at $15. The same product, it is being manufactured in a country at a very lower rate, and it is available in India by way of import at maybe $9. Obviously, what will a layman do? He will go and buy the product at $9 because that is more cheaper for him. The same product, the same quality, same make, everything being the same. So what happens to the domestic market? Domestic market is being impacted badly. So the main purpose of levying import duty is to ensure there is a fair trade practice, and all the products, when it comes to the domestic market, it is having a fair trade and they are all equal. Similarly, a product, there is an acute scarcity in the domestic market, but the manufacturers are exporting it. Then what will happen to the domestic market? The domestic market's requirements are not met. Again, to protect the domestic market, government will charge an export duty, making the export more costlier and discouraging export and ensuring the product is available in the domestic market as well. So it is to ensure fair trade practice that customs duty is being charged. So all the duties that we learn going further is based on this concept. Then taxable event. When is customs duty charged? The taxable event in case of an import is bill of entry. The date on which the bill of entry was presented is the taxable event in case of import. But if the bill of entry is presented before the vessel, aircraft or vehicle enters our territorial water or the territorial space, then the date of the entry inwards of that particular vehicle will be considered as the date of entry or the taxable event. This is the taxable event in case of goods which have entered for home consumption. But in case the goods are not immediately entering for home consumption, but it is being warehoused, then what is the taxable event? So the taxable event will be the date of bill of entry when it is presented for clearance for home consumption. So the main important document in customs duty is the bill of entry, which determines the date on which the goods are entering and the customs duty that will be chargeable. In case of export, it is the date on which the goods leave the territorial waters of India. Okay, so that is called as a taxable event in case of an export. So if an export duty is collected before the ship leaves the port, it does not mean that the taxable event has taken place. It is only when they leave the territorial waters, taxable event is taking place. So if goods are exported and the ship sinks within the territorial waters, it does not amount to export and export duty is not applicable. Now, how is the duty levied? So we saw when and where the duty is being levied. Now how will it be levied? So for levying duty, we refer to the rates which are mentioned in Customs Tariff Act 1975. So Customs Tariff Act 1975 has two schedules, Schedule 1 and Schedule 2. Schedule 1 deals with imports and Schedule 2 deals with duty on exports. So duty on import again can be divided into two, specific levy and ad valorem levy. Specific levy is a particular amount that is fixed on the quantum, that is specific levy. And ad valorem levy. Ad valorem levy will be based on the value. The value of the goods which are imported. A particular rate will be applied, like 10% or so. Now, ad valorem levy can again be divided into two, preferential rate and standard rate. Standard rate is the rate which is mentioned in the Customs Tariff Act 1975 and which will be applicable in a general parlance. Now, preferential rate is if India is having a treaty or a trade agreement with any country, it might offer a preferential rate for imports from that country. So the same will be notified by government and wherever it is being notified, preferential rate will apply. So this is the whole picture of how the duty is being levied. Customs duty is not levied in certain cases. What are those cases? In case of pilfered goods, destroyed goods, damaged goods, or when you relinquish the title to the goods. Relinquishing the title means I give away the title to the goods. I am saying I don't want this goods. That is called as relinquishing the title on the goods. In all these cases, why customs duty is not levied? The simple logic is that it is not being made available in the domestic market. So the whole purpose of customs duty, as discussed earlier, is to ensure fair trade practice when in the common market or the domestic market, when the goods are brought to the domestic market for sale. So these goods are not being brought to the domestic market for sale, and hence customs duty is not levied. Pilfered goods means the goods which are stolen. Again, it is not made available. It is not available for the importer as well. He is not taking it for home consumption, and hence the duty is not levied. Now, types of duty, which is the most important part in customs duty. What are the different types of duty? Import duty, there are 7 types of import duties which are being charged. There is basic customs duty, protective duty, safeguard duty, countervailing duty on subsidized articles, anti-dumping duty, IGST, and GST Compensation cess. Basic customs duty is levied as per Section 12 of Customs Act, and Section 2 of Customs Tariff Act 1975 will provide the rate. So Section 12 is your chargeability section, and Section 2 of Customs Tariff Act 1975 provides the rate at which the duty is being charged. So it is the first schedule as we discussed. First Schedule of Customs Tariff Act 1975 provides for the rates of import duty, two rates, standard rate and preferential rate, which is the basic duty that is being charged. Then protective duty. Protective duty, the Tariff Commission will monitor different industries and they will recommend the union government to impose certain duty to protect a particular industry or to protect a particular goods if they feel that there is a threat to the domestic industry. So that is protective duty based on the recommendation of Tariff Commission. Safeguard duty. So protection is for the future if they expect a threat or injury. Safeguard duty is when there is a huge quantity of goods that is being imported in such a manner that it can cause or it is being causing a threat or an injury to the domestic industry. In that case, a safeguard duty is charged. So protective duty is more futuristic, whereas safeguard duty is what is happening at present. Quantum. There is a huge quantum of goods being imported. So there is an exemption when safeguard duty is not charged. When goods are being imported from a developing country and the total quantum of goods imported from that developing country does not exceed 3% of the total import of that article from all the countries put together. And when the aggregate of import from all countries does not exceed, if it is imported from more than one developing country, in that case, the total imports from 2 or 3 countries put together does not exceed 9% of total import of that particular article from all the countries put together. So in these two exemptions, we will not charge safeguard duty. Countervailing duty on subsidized articles. So what is countervailing duty? Countervail is to counterattack something. It is to offset something, reverse something that has been done. So that is called as countervailing. So for example, a country is producing goods at a very cheaper rate because of a lot of subsidies given by the government to promote import or to promote their export to other countries. So in that case, the product when it reaches India for as an imported product, the value of that product will be very less compared to a product that is manufactured in our domestic market, right, and available in our domestic market. So in order to counterattack or offset the subsidy that has been provided by that government, the union government will charge a countervailing duty. And the countervailing duty will not exceed the amount of subsidy that has been granted by that country. So it is to counterattack or reverse the impact of subsidies that has been provided. So that is called as countervailing duty on subsidized articles. Then anti-dumping duty. Anti-dumping duty is when a product is being imported to India at a very low value. So we saw safeguard duty is when a huge quantity of product is being imported to India. Anti-dumping duty is where the value of that product is very less compared to the normal value. Okay, so then that is called as anti-dumping. When goods are being exported by a country, imported to India at a price lesser than its normal value in order to have a destructive effect on international trade. So that is why anti-dumping duty is charged, and the margin of dumping is the difference between the normal value and the export price. So it is the difference between normal value and export price is called as a margin of dumping. Okay, and the dumping duty charged should not exceed this margin of dumping. So it is to just bring the value of that particular product to the normal export price rather than the price at which it is being imported. That is why anti-dumping duty is charged. Then all of these anti-dumping duty, countervailing duty, safeguard duty will not apply to a SEZ unit or a export oriented undertaking. Why? Because again, the product is not brought to the domestic market for home consumption, and hence we don't need to charge these duties on them. So only by if a specific notification is provided by government or it has been cleared for home consumption, that is only when anti-dumping duty will be applied to export-oriented units or SEZs. Otherwise, all these duties, that is anti-dumping, safeguard duty, countervailing duty, will not apply to a 100% export-oriented undertaking or a special economic zone. Now, IGST and GST compensation says. So, a product that is manufactured in India, when it reaches the domestic market, we charge GST on it. Well, on its sale, GST is being charged. So, again, to bring parlance, to ensure that there is a proper trade practice and there is a fair trade practice, there is more equality, IGST has to be charged on import goods as well. In order to ensure there is an IGST or a GST being charged on a domestically manufactured goods on its sale, and hence we need to charge the same GST on our imported goods as well. So IGST will be charged. It will be based on the IGST Act. The rates will be based on IGST Act. GST compensation says, if GST compensation says is applicable to the goods that is manufactured in India and being available for sale in India, like high-end cars, pan masala, tobacco, for these GST compensation cess is applicable. So if the same product is being imported to India, we need to charge GST compensation cess on the imported products as well. That's a small brief of Customs Act and all the topics which are covered in the syllabus of CMA Inter is being summarized for your reference. We'll come up with more videos solving sums as well, solving small case studies, which could also be a question in your exam. All the best. Thank you.